This is in the District Court of Butler County, Kansas, case entitled State of Kansas versus Olga Terry Fowler. It's case number 2023 CR 288. Brett Sweeney appears for the state of Kansas. James Watts is defense counsel. Defendant Fowler appearing from a remote location. Ms. Fowler, where are you currently situated?
KDOC.
Okay, what facility?
The Topeka Correctional Facility.
Very well, thank you. This matter comes before the court at this time for sentencing. Court's docket notes indicate that the defendant appeared before this court on August the 16th of 2024. At that time, defendant pled guilty to an amended count 1, possession of fentanyl, a level 5 drug felony. A pre-sentence report was ordered, sentencing set for today. Court has received a pre-sentence investigation report compiled by Kit Russell, pre-sentence investigator. He is not currently present on the meeting. I trust each attorney has received a copy of the report, and I'll ask the state's attorney first. Is there any objection to the criminal history, which is stated in the report?
No, Your Honor, no objection to the criminal history.
Is there any objection by the defense, Mr. Watts? You're muted, so if you're trying to talk, I can't hear you.
No, Your Honor. Well, I've not consulted with Ms. Fowler as she just came on. The one item that's a felony that she would make her a G is the item that she is currently serving a probation revocation on. So I don't think there's any doubt about it. So no objection.
All right. Hearing no objection, the court will adopt the criminal history as stated in the report and finds that the criminal history score applicable to today's sentencing is criminal history score G, and the court will proceed accordingly. Mr. Sweeney, are you aware of any legal reason why sentence should not be pronounced in the Fowler case here today?
No, Your Honor.
Mr. Watts, are you aware of any such legal reason?
No, sir.
Ms. Fowler, are you aware of a legal reason or any other good reason why the court shouldn't proceed further with your sentencing today?
No, Your Honor.
Court will proceed further then. Counsel, I'm not aware that there's been a motion for a departure sentence or any other sentencing related motion which has been filed and needs to be addressed. Does the state have any such motions to pursue?
None, Your Honor.
Does the defense, Mr. Watts?
No, sir.
Are there any victims or members of the victim's family who desires to address the court in relation to this sentencing? I notice I have some other participants on the meeting that were apparently invited by someone.
Yes, Your Honor.
Okay, who is speaking?
Sarah McKee.
Okay. Ms. McKee, what is your relationship to the victim in this case?
I am his sister.
All right. You may make your statement to the court at this time.
On October 26, 2022, you went to Wichita and obtained drugs such as fentanyl. In the early morning on August 27th, 2022, I lost my brother, my best friend. As I watched his lifeless body laying on the garage floor being worked on by paramedics, he died from an overdose. You had given him fentanyl, the same drug that you, being a habitual drug user for years, know can cause death. You did not use life-saving measures such as Narcan, something that you knew how to obtain. You did all of this several feet from his children. A father was lost that day. I do not feel sorry for you. Instead, I feel sorry for the victims, my brother, his children, my parents, my sister, his brother-in-laws. You had a choice many years ago not to use drugs. You have had several chances to get clean and not use drugs, but you still used, have done all of this knowing the causes and effect of what drug use can do. You have not been a good member of society. Because of your recklessness, I'm going to spend the rest of my life without my brother, without my best friend.
Very well. Thank you, Ms. McKee. Are there any other victims' family members who desires to address the court in relation to this sentencing?
Your Honor, I do.
Okay. And your name, sir?
Brad Meyer,
Okay. And your relationship to the victim in this case?
Simon's brother-in-law.
You may address the court with your statement at this time.
I'm reading this today with a heavy heart and a deep sense of sorrow to share the impact of a tragic loss of my brother-in-law, Simon Shivers. Simon was killed by a lethal dose of fentanyl given by you, Terry Fowler, on August the 27th, 2022. As we navigate through this incredibly challenging time, I feel it's crucial to express the profound effects this devastating event you created has had on our lives, particularly my nephews, Shiloh and Silas Shippers. The loss of Simon has left an irreplaceable void in our family. He was not only a beloved brother, son, and brother-in-law, he was also a very devoted father to two very young boys. Their innocence was shattered that night while you allowed their father to lie dying in the garage floor while they slept in their beds only feet away. While they were very young now, not knowing and totally comprehending the enormity of losing their father as a direct result of such a senseless act, they will never get to know just how great their father actually was. Simon touched so many lives being a master of his trade. Simon was an artist, and it shows in both boys every single day. Simon always took time out of his busy schedule to make sure the boys always had what they needed, which often meant working late into the night to make sure of that. While I never saw you work much at all, or much less into the night. Witnessing their pain and their confusion has been heart-wrenching for all of us. As the only family my nephews have left, our whole family has quickly adapted to having them in our home and providing them with the stability, the love, and the support amidst our own grief. We're committed to ensuring that they have a safe, nurturing environment to grow up in, but the emotional toll of this responsibility is immense. We're haunted daily by your senseless act that took Simon's life. Moreover, you knew the effects of your actions and chose to make a trip to Wichita that very evening to get the fentanyl that would ultimately kill Simon and take him from his boys. The trauma of his death has left deep scars within our family that will never, ever heal. The boys are in a great place now, but no thanks to you. As a family, we talk daily about Simon. We talk about it with the boys, even if it's just to say, you're acting just like your dad. To which they will respond and laugh and go right on doing what they were doing. But the boys may never say anything about you. They never talk about you. They never ask about you. I believe that fateful night in August, they lost both parents. Boys won't hesitate to tell someone that their dad did this or their dad did that. Or they remember doing this or that with their dad, but they don't talk about you. The boys are doing great in school, including perfect attendance awards and honor roll, when in 2021, they were not doing well. Poor grades, poor attendance, and only got to school when Simon could make sure they got to school because you didn't do those things. They are in several extracurricular activities that brings out their true personalities, which you would never do, only being worried about your own deadly desires, while their father worked tirelessly to provide for everyone. Terry, you've done nothing throughout this whole process since the 27th of August, except continue down your deadly path. And it's my prayer daily that your path and their paths never cross again. Because you don't deserve them. You deserve exactly what you've got right now. I could go on and on about what you never did for the boys, but everyone already knows, including the boys. To think about your actions in 2022 will get you little to no jail time in the eyes of the court, and that you will be out walking the streets again, living your deadly lifestyle, while Shiloh, Silas, Sarah, Susan, Charlotte, Darlene, Gerald, and Jake, and I will live forever with the grief and the hole in our lives because of your actions on August the 27th, 2022. It is sickening and disgraceful. Thank you, Your Honor.
Very well. Thank you, Mr. Meyer. Are there any other family members who desire to address the court in relation to this sentencing? Court finds that no other persons desire to address the court to make victims' family statements. So we'll move on at this time to recommendations from legal counsel regarding an appropriate sentence for the defendant, beginning with prosecuting attorney Brett Sweeney on behalf of the state.
Thank you, Your Honor. Your Honor, pursuant to plea agreement, the state is recommending the aggravated box, these 16 months in the Department of Corrections. We're recommending the aggravated box, just given the circumstances and the nature of this offense, which I know the court has heard the preliminary hearing evidence on. Additionally, I would note that this is a second possession offense, and also would, I think it's worth noting, is a second strike, which does have some implications in Kansas law as well. The state's recommending the maximum good time. Well, she would be eligible for a maximum good time percentage of 20%, as well as have a post-release supervision duration of 12 months. Your Honor, as far as the jail time credit goes, I would acknowledge that she has been in custody on this case since January the 18th of 2024. However, I would note that she was revoked from her probation on 23 CR 25 in May of this year. I guess she technically still would have had a May 17th. She technically still would have been on bond in this case. And I know there's some recent and relative case law to that, but I just did want to point that out. Additionally, Your Honor, I would note that she's obviously, the court has a PSI in front of it. This is a presumptive probation case, and given her pre-sentencing evaluation scores, she scored one of the highest scores I think I've ever seen on one of these evaluations. But that put her in the mandatory Senate bill position, and so I think it kind of is what it is. The state would acknowledge that she needs to be put on community corrections probation for a period of up to 18 months, and that would include obviously the recommendations that are included in the treatment evaluation that's also included in the PSI. That appears to be intensive outpatient treatment with a number of different aftercare components that are involved with that. The state would recommend that all of those be adopted. I would also note that this is not always standard, but there is a mental health treatment component that's being recommended within the PSI as well. I would ask that that be adopted as a condition of probation, although I don't think that that is necessarily covered under the subsidized Senate bill rubric. Additionally, the state's asking for the adoption, of course, of all the conditions within the PSI. One specifically, I would note, is no contact with the co-defendant, Nathan Allen Carr, and then also that she comply with any other court orders and any other cases that she may have ongoing. Your Honor, as far as any other costs and fees, the state is not requesting a fine in this case. We are requesting, of course, the court costs in the matter. There is no DNA. She's got a prior possession that she was revoked on. We are requesting the Senate Bill 123 fee in the amount of $300. And the state would be requesting that the court take a look at attorneys and bids fees if appropriate. And Your Honor, I think with that, that's all I have to offer for the court.
Very well, Mr. Sweeney. Mr. Watts, your recommendations regarding an appropriate sentence?
Thank you, Your Honor. Pursuant to plea agreement in this case, we would join the state's recommendation as to the aggravated box, the upper box, and the grid box of 16 months in the Department of Corrections. As Mr. Sweeney has noted, this is a Senate Bill 123 case. As Mr. Sweeney has also noted, and I've explained to Ms. Fowler as well, as I know she well understands, this is a second of what could be at some point a third strike. So if Ms. Fowler comes back on a third possession of methamphetamines, or third possession of any felony drug, by the way, for that matter, she's looking at a presumptive prison outcome rather than a presumptive probation outcome with the Senate Bill 123, which is where we're at this case. She's currently in the Department of Corrections, as we all know, as she appears from there. It's important to note, however, that her out date for the Department of Corrections at this point is less than a week away. So she can easily step into the Senate Bill 123 treatment program that is called for, and it's certainly called for in this case. Further, while the PSI calls for 236 days of credit, I think that should also include the days up to today pursuant to the recent case law. She went into custody on this case, I think on the July 18, and as far as I know, has never left custody in this particular case. She's been in custody, I think that entire time. It certainly would seem to reflect that. Now, I understand she's been in the Department of Corrections custody as well, part of that time, but pursuant to the current case law, the most recent case law, I don't think that means she cannot get credit for those days. By my math, she would get 274 days, which would be the 38 days from September 10 to today's date. Judge, I think I should just leave it at that.
And Your Honor, if I may piggyback on that just very briefly.
You may.
I mean, I think that's accurate on the jail time credit to the extent that the court doesn't run these two cases consecutive. Certainly, if this case was run consecutive to that case, then she's only going to get credit for jail time credit in one case. And I obviously I think the court's aware of that. I just wanted to throw that out there.
And I agree, Your Honor, that would be correct should the court run them consecutive.
All right. I have Jessica Morgan here from the Court Services Department, and I realize, Ms. Morgan, you didn't compile this report, but why did Mr. Russell stop the jail time credit running as of September the 10th? Do you know?
Your Honor, I am not aware of why he stopped it on September 10th, and there's no information in the PSI or in the file. So I apologize, Your Honor.
No, that's all right. Just thought if you had some explanatory information that you could provide it to the court, but I certainly understand. All right, very well then. Mr. Watts, what are your fees in the representation of this client?
Your Honor, this was billed to bids at $2,400.
All right, thank you.
And I'll note, Your Honor, what I'm sure the court has assumed, and I think is correct, that September 10 date was her admission date to the Department of Corrections.
At this time, the court will address the defendant, Olga Terry Fowler, personally, and I'll ask her if she has any statements that she wishes to make in mitigation of punishment or anything further that she would like to present to the court. Ms. Fowler?
Right before I was arrested, I completed inpatient. The PSI that you guys are looking at was completed before, on my first possession felony. I tried to get a new PSI to you guys, but I was brought to KDOC and I couldn't get the paperwork. What happened that night was horrible. And I don't deny that part of it was my fault, but I live with that every day. I don't have my kids. And I know what I've lost. I'm sorry. I don't know what else to say.
Very well, Ms. Fowler. Court will pronounce sentence in this case at this time. Court hereby establishes count 1 as the base sentence in this case for the offense of possession of fentanyl, a severity level 5 drug, non-person felony, in which the defendant has a criminal history score of G, thus placing her in grid box 5, drug G. The court hereby sentences the defendant to the aggravated term of 16 months in the custody of the Secretary of Corrections of the state of Kansas. On this sentence, the defendant may earn up to 20% of good time credit and would be subject to 12 months of post-release supervision. Court has considered but declines to impose a fine in this particular case. Regardless of what this court may feel the appropriate sentence is in this case, Ms. Fowler, the court is constrained here. The Kansas legislature has determined that someone with your very high risk score on your risk needs assessment, combined with the high probability of you having a substance abuse disorder, means that you are mandatorily to be granted probation as part of a state-sponsored drug treatment program. One could quarrel as to whether that's the appropriate sentence in this case or not, but when the legislature says it's mandatory, according to case law, it means mandatory. So the court will sentence you at this time to a drug treatment program until deemed suitable for discharge for up to 18 months, with up to 18 months probation to be supervised by the Community Corrections Department. Conditions of that probation will include reporting to an officer as directed, observing all laws. You must appropriately complete alcohol and drug treatment in connection with your Senate Bill 123 evaluation and assessments, and follow the recommendations of your drug treatment counselors. You will also obtain an assessment for mental health, and the court is going to require that that mental health assessment be done within 45 days of the date of your release from custody. Then you must comply with any mental health treatment recommendations made by your evaluator. At your supervising officer's request and at your own expense, you shall submit to random breath, blood, and urinalysis testing, perform community service work pursuant to program requirements, gain and maintain employment suitably throughout your probationary term, notify your ISO within 24 hours of any change in employment status, residence, telephone number, email address, or any contact with law enforcement. You shall have no contact with the co-defendant, Nathan Allen Carr, currently in case number 2023 CR 307. You shall abide by any curfew or travel restrictions imposed by your officer. Follow all standard conditions of community corrections probation, not have in your possession firearms or dangerous weapons, and avoid disreputable characters and places. Ms. Fowler, some people leave the court at sentencing without a faintest idea as to what disreputable characters and places means. Disreputable characters would be anyone who would expose you to any type of illegal drugs. Pure and simple. And disreputable places is anywhere where you might be where those people are. You'll need to govern your behavior accordingly. You shall also make monthly payments on your obligations in a manner acceptable to the court. The court will be assessing a felony docket fee, felony probation fee, community corrections fee, $300 reimbursement to the Senate Bill 123 treatment program. Bids or assessments are waived given the defendant's incarcerated status currently. Court does not have adequate information in which to base bids orders, though obviously legal services have been very valuable to her. Court must waive those at this juncture. Ms. Fowler, once you're out, I'm going to require you to pay at least $100 a month on your obligations. I don't think that modest amount is going to work a burden or hardship on you or any member of your family once you're out and working. And that will start with the first full calendar month after you get out of custody. And every subsequent month until your case is paid in full. Regarding the issue of jail time credit, the court will be awarding the defendant what the court computes to be 274 days, making a slight adjustment to the jail time credit figure that's on the face sheet of the pre-sentence report. Court will be awarding 274 days credit in this case. I don't believe that there was an actual request for restitution here of any kind. Is there, Mr. Sweeney?
No, Your Honor. My understanding is there's no dollar amount that's being requested.
All right. Ms. Fowler, I'll inform you that criminal defendants under certain circumstances have the right to appeal a conviction to an appellate court having jurisdiction. If they are unable to pay the cost of an appeal, a defendant may request the court to appoint a lawyer to represent them on appeal, and that they be to direct that they be supplied with a transcript of trial court proceedings. Pursuant to KSA 223608C, you, the defendant, have 14 days after this judgment in court to file any notice of appeal with the clerk of the District Court of Butler County, Kansas. And you do have the right to appeal this sentence if the court has ruled adversely to you at this hearing. I will remind you that there's prohibitions against a convicted felon possessing a firearm, and that there are losses of certain civil rights, such as the right to vote, until your sentence is fully discharged. Furthermore, Ms. Fowler, it's not the responsibility of a community corrections officer to chase you down after you're released from custody, but rather your responsibility to contact the community corrections department the first day that you are out. So I do have Marcy Taronas, an ISO with community corrections, on this meeting. I don't have a lot of time, Marcy, but we can leave the meeting open so that you can confer privately with Ms. Fowler and give her some direction as to what else she needs to do to get started on her community corrections upon whatever release date she has. So Ms. Fowler, stay on the meeting a little longer after I recess so the ISO can talk to you, okay?
Okay.
All right. Mr. Sweeney, were there any other sentencing related matters that the court needs to address?
Not from the state, Your Honor.
Mr. Watts, is there anything further that the court needs to address?
I don't believe so, Your Honor. Thank you.
Ms. Fowler, do you have any questions regarding the court's sentencing orders?
No, Your Honor.
You cannot come back, Ms. Fowler. You have one opportunity to take advantage of the state's sponsored treatment program and successfully complete this community corrections probation. Do not leave here today thinking that you're going to get multiple opportunities to be successful. You have this opportunity today. Seize it. And once and for all, break this grip that drugs has on you and your life with the toll that it takes not only on you, but everyone around you. Good luck, Ms. Fowler. I hope you're successful. If there's nothing further then, the Olga Terry Fowler matter will currently be in recess, and this meeting may be ended for all.